Saskatchewan's Court of Appeal has reserved its decision in the challenge to the province's youth pronoun law. The court heard arguments over 2 days about the law that requires parental consent when children under 16 want to change their names or pronouns at school. A judge ruled earlier this year a challenge of the law could continue, even though the government invoked the Notwithstanding clause to override certain charter rights. The province has asked the appeal court to quash that ruling. Joining us now to explain is human rights lawyer Bennett Jensen from legal advocacy group Egale. Let's start by having you give some background information for our viewers on this case.
So I think it's easiest to start with where we are and then take a step back. What happened last week was that there were legal arguments, quite technical legal arguments, about the role of a court once a government has used the notwithstanding clause. So simply put, the governments of Saskatchewan, New Brunswick, and Alberta say that the court has no role. And we, along with a number of intervener groups, say that the court retains a critical role when a government acts to violate charter rights of especially a vulnerable group of students.
Okay.
Taking a step back, about a year ago, we launched a constitutional challenge to the province's, Saskatchewan's new policy, which required parental consent for gender diverse young people under 16 when they wanted to informally change their names or pronouns at school. And there's been a lot of misinformation, so I'll just make two brief points. The first is that we all believe and agree that all parents want what's best for their children, and that most parents will be able to love their kids through the experience of coming out as queer or trans. But unfortunately, there is a portion of parents that won't be able to do that. And those are the young people we're worried about. So we know that for young people who aren't able to get support at home, having access to a single supportive adult, so a teacher or a coach who sees them, affirms them, and helps them just feel comfortable in who they are, can be the difference between making it to adulthood or not. The stakes are really high here. So this is a population that has much higher rates of suicidality, homelessness, abuse, addiction, if they are denied affirmation. And the reality of that is such that a court earlier on in these proceedings recognized that the government's policy would cause irreparable harm to gender diverse young people. So what we're really talking about is making sure that schools have the ability to be a safe haven for all students who may need it. And unfortunately, the government's used the notwithstanding clause to implement its policy. So that's what we're in court about.
Okay, yeah, there are some parents who want to be involved in their children's decisions. You did mention that. Saskatchewan Premier Scott Moe says this is to provide parents with the right to be involved in their child's education and life. He says it's not about targeting anyone. What would you say to that?
Well, I think, again, there's a lot of misinformation. Nobody is saying parents shouldn't be involved in their children's lives. We all agree that there is nothing more important than supportive parents for all young people. We're talking about a particular minority of an already very vulnerable population that wants to informally go by a different name or pronoun. And in terms of it not targeting vulnerable people, that just doesn't hold water. So the Premier's been very clear that if a cis, a non-trans student wanted to go, by Matt instead of Matthew, their parents wouldn't have to consent. But for gender diverse people, if that's the reason that they want to change, the name that teachers informally call them at school, then a parent has to weigh in. So this is absolutely on its face discriminatory. And that's why the government has had to use the notwithstanding clause, I would say, because they're also aware that this policy violates the charter rights of the population in question.
Okay, let's talk about Egale Canada. What's your organization's involvement in this particular case?
So we represent the local organization. So we're the lawyers, along with McCarthy Tetreault. We're co-counsel in this case on behalf of You Are Pride, a local organization in Saskatchewan that provides direct services to gender diverse young people, among other populations in the country, in the province, excuse me.
Okay. Now, you did mention that you're aware that there are some parents that want to be involved in these decisions, and but there's also a group of parents that maybe aren't as supportive. What would you say to the parents that are reacting a bit fearful in this situation of not being able to provide that support to their children, or for those who aren't as educated about the topic? Is there a place they can go for more education about this? Is there a way for them to feel more comfortable in a situation like this?
Well, the first thing I would say is that I understand if you don't know something, if you, excuse me, if you don't know trans people, or if you don't know what it means to have a trans young person, a child, it makes sense that this would be scary because the only thing you hear in the media and from your leaders is is that bad things come from this. And I don't mean to be overly simplistic, but I think that makes a lot of sense. Um, I think that there have been a lot of really brave families, parents of gender diverse young people that have spoken out in opposition to this policy and the policies pursued in New Brunswick and what has been um, announced for Alberta. So I would really listen to those families and try to see behind the rhetoric that we're hearing at the political level and listen to parents who can talk about how important it is that all young people have a sphere of independence at school where they're able to explore themselves in a sort of lower stakes way, and come out to their parents when they're ready if that's a safe thing to do. So again, we're just talking about informal pronoun and name change at school. No official name changes, nothing like that.
Okay, Bennett, what's next for this case?
So, as you mentioned, the Court of Appeal has reserved its decision, which means it's going to take some time to make its decision and release it, um, and we'll go from there. There's a case dealing with similar issues out of Quebec, the Hack case, in response to Bill 21, that's being heard by the Supreme Court of Canada. Um, we anticipate at some point in the next year it's sought leave. The lawyers there have sought leave, and so we expect to get guidance from the courts about the notwithstanding clause and what it means when a government uses it.
Bennett, thank you so much for sharing your perspective with us today. That's Bennett Jensen,
Thank you.
human rights lawyer at legal advocacy group Egale.